Today is a joint hearing on the subcommittees on commerce, trade, and consumer protection, and communications technology and the internet. And I want to welcome all of you to this hearing, and I want to just give you some advance notice that in about 20 minutes we will be called to the floor for a series of votes. Some have estimated it to be was scheduled for about 27 votes on the floor, which is certainly going to extend the hearing. And so we ask that you be patient with us. We'll try to conduct this hearing and try to be very mindful of your time, but we will be dictated. Our actions will be dictated by the House schedule and by the votes on the floor. Now I want to recognize myself for 5 minutes of opening statements. As I indicated, today the two subcommittees, Commerce, Trade, Consumer Protection, and Government Technology and the Internet, combining our commitment to privacy and our resources to conduct an extremely important hearing on behavioral advertising, industry practices, and consumer protections. And I want to just take a moment to thank Chairman Boucher for not only his cooperation and our working together, our teaming up on this particular issue, but I want to thank him also for his past championship and dedication to this very, very important issue. This is but one hearing along a continuum of legislative activity examining the domains of online and offline consumer privacy and how companies handle and treat consumers' personal information. Most recently, the Subcommittee on Commerce, Trade, and Consumer Protection, which I chair, marked up H.R. 2221, the Data Accountability and Trust Act, a bipartisan bill which addresses security of personal information, breaches of that security, and corrects some of the resulting harms to consumers. I'm hopeful that there will be more hearings. There are currently no federal laws specifically governing behavioral advertising, nor do we have a comprehensive general privacy law. As members of Congress, we have anticipated for some time that this hearing would be highly informative and very valuable in helping us answer the question that everyone seems to ask: is federal privacy legislation necessary, or should companies be trusted to discipline and regulate themselves? At this hearing, I look forward to hearing from our very distinguished panel of witnesses about this growing trend of online behavior advertising. Market research firms have estimated that behaviorally targeted ad spending will reach $4.4 billion by the end of 2012. That number is eye-opening, as it translates into almost 25% of all online display and spending that is projected to be spent by year 2012. As prevalent as these ads are becoming, so too are the buzzwords, which are purportedly needed to flesh out the appropriate contents of fair information principles and practices. Words and phrases such as transparency, choice, notice, consent, consumer expectation, opt-in and opt-out seemingly mean different things to different speakers depending on an array of variables. There is some feedback here. Has that been
Great.
Such variables may include the identity of the user, whether he or she has registered with the visited website, whether the ads are being served by first or third-party sites, the sufficiency and conspicuousness of pre-existing privacy policies and disclosure, the robustness of user-enabled settings for managing user privacy, and the list can go on and on and on and on. All of these variables are important to consider, but they can muddle the issue of whether legislation is needed. And I will be listening intently to your accounts of how upfront companies have been about the types of personal information that they are collecting from consumers, what they're doing with the information, and what choices and controls that consumers have over the subsequent use of that information. And I want to thank all the witnesses for coming in this morning, for sharing with us, taking away from your busy schedule to provide input, much needed input into these matters that's before us today. And I want to thank all the subcommittee members and the staffs for so diligently preparing us, this subcommittee, for these hearings. And now I want to recognize for 5 minutes, for the purposes of opening statements, the ranking member, Mr. Vodanovich. Mr. Vodanovich is recognized for 5 minutes for opening statements.
Thank you, Mr. Chairman, and I want to thank you and Chairman Boucher and my fellow ranking member, Mr. Upton, on these hearings today. I think it's a good issue that we need to be talking about. Privacy continues to be an issue of increasing concern to consumers, and I'm pleased that we'll be looking at all the relevant issues to determine what the problems are and what possible solutions exist. What was once thought to be an issue limited to business with whom consumers had a customer relationship has been forever altered by the Internet. Progression and innovation in computer and digital technology over the last 20 years has transformed many aspects of our lives. And by the same token, that progress has opened the possibility to potential abuses and invasions into our lives. In the connected world of the Internet, where data is instantaneously accessible to anybody in the world, we have learned how vast amounts of sensitive consumer data can be inadvertently disclosed or subject to more malicious and intentional theft. We also know the main reason consumers should be concerned about the amount of personal information out there on the World Wide Web is that sensitive personal information can be used for harmful purposes, particularly identity theft. Thankfully, we are addressing some of those concerns with the data security and breach notification legislation moving through the committee right now. Our oversight into the data security issue opened our eyes to the types of sensitive personal information many institutions, ranging from businesses to government, maintain about us. And while information is kept about us, maybe for legitimate reasons that mandate data retention, for instance, for law enforcement purposes, most consumers do not fully understand how information gathered about us will be used or with whom it will be shared. These concerns are legitimate. What is more, these concerns over keeping personal information private are exacerbated by digital technology and the capabilities of Internet technology. Information that filled rooms of file cabinets in a paper-based business can now be stored on devices that attach to a key ring and can be sent over the Internet in seconds, making information theft easy and often untraceable. The ability to instantaneously collect, analyze, and store consumers' online behavior for marketing purposes stretches this dynamic even further. The Internet quickly evolved beyond its original purpose as a communication tool to become a means of commerce, education, and social interaction. A generation has been raised on the Internet with the ability to find information relevant to their interests and communicate in ways that we could not imagine only 10 years ago. And most expect these services to be customized for their preferences. But many of these technologies and practices that deliver high levels of customization present new challenges and concerns for consumers, primarily understanding what the trade-off is for these services. Do we need to relinquish personal information about ourselves and our internet for the purposes of generating more user-specific advertisements in exchange for access to the information we seek on the internet? And if so, who has our access to this information? The internet has been a successful tool for commerce and has benefited consumers with convenience, choice, and savings. Relevant advertisements based upon user interests will be more beneficial to the consumer and business, which in concept is no different than the manner in which marketing research determines which advertisements are selected to be placed in magazines, newspapers, or on television based on the intended audience. However, in practice, the internet is different because of its ability to track preferences on a minute-by-minute basis. The question is how advertisers engage in the process of identifying their potential target audience. Specifically, what information is used to generate targeted advertisements. I have a son who I would do anything to protect, and although I cannot monitor him every waking moment and prohibit his ability to access the internet, nor would I want to, like any parent, I want to trust that he will be safe to surf online and interact with his friends without being unknowingly monitored or profiled. While my son is in a vulnerable demographic, millions of Americans of all ages spend time surfing, posting, and shopping on the internet. How their information is used and what control the individual has over the collection of their information is at the center of the debate of whether we need a federal privacy law, and if so, how it should be structured and what activities it will address. In the case of my son, I am concerned with the information being gathered and how it is used. I'm less concerned with who is conducting the behavioral profiling or what technology they are using. I thank the witnesses today, and I look forward to your testimony, particularly hearing more about what the industry is doing to address many of these concerns in and of itself. Mr. Chairman, I'm ready to work with you and the stakeholders to address identified problems and ensure whatever solutions develop will equally apply to the behavior regardless of who engages in it. Thank you, Mr. Chairman.
The Chair thanks the gentleman. It is now my privilege and honor to recognize for 5 minutes for the purposes of opening statement the Chairman of the Subcommittee on Communications Technology and the Internet, the gentleman from West Virginia, Chairman Boucher, for 5 minutes.
Well, thank you very much, Chairman Rush, and I want to begin this morning by saying thank you to you and to your very fine staff, and to Mr. Radonovich from California, your ranking member, as well as to Mr. Stearns and his staff for the excellent cooperation we've had among ourselves as the plans for this joint hearing of our two subcommittees have progressed. I very much look forward to our continued collaboration as we consider the need for legislation and discuss the principles that privacy protection legislation should embody. Broadband networks are a primary driver of the national economy, and it's fundamentally in the nation's interest to encourage their expanded use. One clear way Congress can promote greater use of the Internet for access to information, for electronic commerce, and for entertainment is to assure that Internet users have a high degree of privacy protection, including transparency about information collection practices and uses, and control over the use of the information that is collected from those who use the Internet. I've previously announced my desire to work with Chairman Waxman, Chairman Rush, and ranking members Barton, Stearns, and Radonovich in order to develop legislation this year, extending to Internet users the assurance that their online experience will be more secure. Such a measure would be a driver of greater levels of Internet uses, such as electronic commerce, not a hindrance to them. Today's discussion will examine behavioral advertising and ways to enhance consumer protection in association with it. I'm a supporter and a beneficiary of targeted advertising. I would much prefer to receive Internet advertisements that are truly relevant to my particular interests. In fact, I have bought a significant number of items based upon targeted advertising delivered to me from websites that I frequently visit. And so I have a deep appreciation of the value of targeted advertising from the consumer perspective. It's important to note also that online advertising supports much of the commercial content, applications, and services that are available to Internet users without charge. And I have no intention of doing anything that would disrupt that very successful, in fact, essential business model for Internet-based companies. At the same time, I think consumers are entitled to some baseline protections in the online space. Consumers should be given clear, concise information in an easy-defined privacy policy about what information a website collects about them, how that information is used, how long it is stored, how it's stored, what happens to it when it's no longer stored, and whether it's ever given or sold to third parties. Consumers should be able to opt out of first-party use of the information and for its use by third parties or subsidiaries who are a part of the company's normal first-party transactions or without whom the company could not provide its service. All of that would fall within the ambit of opt-out. Consumers should be able to opt in to use of their information by third parties for those parties' own marketing purposes. This arrangement should not prove to be burdensome. In fact, it's very much in line with the practices of many, if not most, of the reputable service providers today. I look forward to hearing from our witnesses about their reactions to this arrangement and how it can best balance Internet business models that depend on online advertising with adequate protection for consumers' privacy. For example, have I suggested a workable online opt-in and opt-out consent arrangement, or are there additional situations in which opt-out consent might sometimes be appropriate? What safeguards should be in place in order to ensure that consumers are giving meaningful consent to the sharing of their information both on and off the Internet? What role could self-regulatory organizations play in a statutory arrangement that ensures that all entities that collect information about Internet users abide by a basic set of consumer privacy standards? I also look forward to learning about emerging approaches to enhancing consumer choice and control over the use of information through efforts like the Network Advertising Initiative and persistent opt-out cookies. What benefits could these services offer to consumers? What is the best way to inform consumers about the availability of these services? And again, how should the consumer's meaningful consent be procured? I'm also interested in hearing a purview of what the future of behavioral advertising may hold and what services it might enable and how to accommodate privacy concerns associated with those future services. I want to thank our witnesses for taking the time to join us here today. They represent a broad and diverse range of interests and are all deeply knowledgeable about these subjects. We very much look forward to hearing your testimony. Thank you, Mr. Chairman.
The chair thanks the gentleman. The chair now recognizes the ranking member of the subcommittee on communications, the ranking member, Mr. Stearns from Florida. He's recognized for 5 minutes for the purposes of opening statements.
Good morning, and thank you, Mr. Chairman. I also want to echo Mr. Boucher's comment that we look forward to working together in a bipartisan fashion on a very important bill. And I want to thank the witnesses for coming this morning. I think, for the most part, you're going to educate us. You're the experts here, and we respect your opinions. We want to do no harm here. So I think when you look at this possibility of federal legislation dealing with privacy, we want to make sure that it's consumer-centric. Consumers don't care if you're a search engine or a broadband provider. I just want to ensure that the privacy, their assurance that their privacy is protected. We must empower them to make these privacy decisions themselves. They feel, they know how much want to be collected and what should not be collected. Congress cannot and should not make that decision for them, but it can play a role in making sure consumers have the information simply to make their own choices. That means companies should be as transparent as possible about what information they collect and, of course, how they're using it. That way, consumers will be better able to make informed privacy decisions. This transparency should include robust disclosure and notice outside the privacy policy. Notice and disclosure needs to be clear and conspicuous so the consumers know that. First, some information is being collected. Second, what is the information that's being collected? How is it being used? And third, how to prevent this information being collected if they so desire. By giving the consumer more robust and transparent information, we can strike the proper balance between privacy protection and strong Internet commerce. Furthermore, my colleagues, I want to emphasize two principles that should play a prominent role in our examination of this issue. First, we should apply the same privacy standard to companies that are engaged in similar conduct with similar information. But we should avoid applying those same standards to entities that do not use the same types of information for the same purposes and do not have anywhere near the same volume of information about the prospective consumer. For example, search engines and Internet advertising networks may use a consumer's visit to a particular website to create profiles for purposes not directly related to the reason for the visit. Other entities, like web publishers, collect information only to provide the very service the consumer has come for. Our approach should recognize that. Second, any legislation in this area should hold various parties accountable only for that which they know and control. We should be wary of efforts to make any one party responsible for the actions of others. Consumers' online activities provide advertisers with valuable information upon which to market their products and their services. Collecting this type of information for targeted advertising is very important because it simply allows many of these products and services to remain free to consumers. Without this information, websites would either have to cut back on their free information and services or would have to start charging a fee. Neither result is good for the consumers. Overreaching privacy regulation could have a significant negative economic impact at a time when many businesses in our economy are struggling. So let's be very careful on these issues before we leap to legislative regulatory proposals. When I was chairman of the Commerce, Consumer Protection and Trade, I held a number of hearings on privacies. I worked with Chairman Boucher, and we developed the Consumer Privacy Protection Act, which we dropped as a bill. This bill would have required data collectors to provide consumers with information on the entity collecting the information and the purposes for which the information was being collected. I believe it was and still is a good base bill to use as we move forward to develop a new privacy bill. Also, I'd like to bring up an issue perhaps that many of us have thought about, and I don't want to bog down our discussion about it. Which agency will regulate and enforce privacy standards? Will it be the FCC or the Federal Trade Commission, a combination or possibly a new agency? I know this issue won't be solved this morning, but it's something we're going to have to work out and work through, and I look forward to doing this on a bipartisan fashion. And I'd be interested, if possible, if some of the witnesses could give us their feelings about how the jurisdiction of this privacy bill would be best supervised with. So, Mr. Chairman, I would conclude by pointing out we've talked a little bit in previous hearings about deep pocket inspection. The point is that whether a company uses deep pocket inspection or reads your email directly, this should be part of the privacy rules in some way. So I think our witnesses can also help us on that particular aspect. So I look forward to hearing, and thank you for the opportunity to speak.
The chair thanks the gentleman. The chair now recognizes the gentleman from Ohio, Mr. Space, for 2 minutes for the purposes of opening statements.
Thank you, Chairman Rush and Chairman Boucher, Ranking Member Radonovich, and Ranking Member Stearns for convening us today on the topic of behavioral advertising. I was struck when reviewing Professor Felton's testimony by a comment that he makes. Quote, responsible ad services typically collect less information and track users less intensively than the technology would allow, end quote. To me, this means that just because we can doesn't mean that we should. I certainly understand the need for companies to advertise on their sites. Doing so is what enables our constituents to access free content, products, and services online. And I also understand the desire of ad companies to supply consumers with ads that are of more relevance to them. This is a better business model for the companies and potentially a service to consumers. However, I want to make clear that one bad apple could spoil the whole bunch here. The moment online consumers believe their personal information is at risk of corruption, misuse, or theft will be the moment this approach we are discussing today will cease to work. I strongly believe it is in the interest of all parties to disclose to consumers their advertising practices and intent, and to ensure that consumers' personal information is strictly guarded against security breaches and exploitation. I look forward to these conversations today and to working with my colleagues on this issue as we move forward. I yield back my time.
The chair thanks the gentleman. It is now my pleasure and honor to recognize for 5 minutes for the purposes of opening statements the ranking member of the full Committee on Energy and Commerce, Mr. Barton, is recognized for 5 minutes.
Thank you, Mr. Chairman. As I look on the other side of the aisle, I am gladdened to see that none of the Democrats that played on the Democratic baseball team are actually in the room. So I can congratulate them in their absence, and I won't have to do it face to face when I see them on the floor. But last night, Mike Doyle, who is the manager of the team, Bart Stupak, who is on this committee, played an amazing game. It wasn't their usual Democratic bumbling era game. They actually played very well and as a team, and as a result, they beat the stalwart Republicans 15-10. John Shimkus, who is our starting pitcher, played an excellent game, and we had a number of Energy and Commerce Republicans. Mr. Gingrich, Dr. Gingrich, who's here, walked at a key time and later scored. Mr. Scalise, who is here, played second base some and also did some base running and scored. So Mr. Pitts, he came out and watched the game and luckily didn't try to play, although we could have used his bombing skills from the Vietnam War. So anyway, we raised quite a bit of money for charity and had a good time. And when y'all see Mike Doyle and you see that he's grinning from ear to ear, just congratulate him and tell him to take pity on the downtrodden Republicans who didn't quite have the stuff last night. On this hearing, Mr. Chairman, I do want to thank you, thank Mr. Boucher, Mr. Stearns, Mr. Radonovich for working in a bipartisan fashion to protect the privacy and security of every American's personal information. I'm glad that we are working on this in a bipartisan way. I especially appreciate Chairman Rush's agreement to act on the Republicans' data security bill. That bill has implications for the broader privacy discussion, and I hope that that bill will move forward in the full committee. Along with Congressman Markey, I co-chair the Congressional Privacy Caucus, so I'm glad that we are working on these issues in a bipartisan way. I myself, every few days, hit the delete button and clean out all the various cookies on the computers that are in my office and at my home. It's amazing to me how many of those accumulate, and most of the time without absolutely any knowledge of myself or anybody else for that matter, that they're being put on our computer. I think it's a big deal if somebody tracks where you go and what you look at without your personal approval. We wouldn't like that in the non-internet world, and I personally don't like it in the internet world. The information about myself is mine. Unless I choose to share it, I would just assume that it stay my information only. I think that I have the right to know what information people are gathering about me and the right to know what they're doing with it. It's obvious that the public agrees with the statement that I just made because poll after poll shows that They think that their information and their right to privacy is just as important on the Internet as it is in the non-Internet world. When I open an email for the new Dallas Cowboys Stadium that is in my congressional district, I don't expect to begin receiving unsolicited ads for airline tickets to the Dallas-Fort Worth area or hotels, also in my district in Arlington, Texas. It's obvious that people track what I do and where I go and try to take advantage of that. Fortunately, technology has come quite a ways in protecting the individuals. We started looking at the spyware problem back in the 107th Congress, and thanks to the work of, among others, Congressman Mary Bono Mack, Ed Towns, Chairman Dingell, those spyware infections are not near the problem that they used to be. However, today, companies continue to gather, maintain, and use data through a variety of technological methods. Some of those companies, such as Verizon and Comcast, are large companies. They're regulated in some parts of their business model, and I think they are trying to act appropriately. There are other companies, so-called ISP locators, that I personally don't even know their name. Then you have the in-between companies, the so-called edge companies like Yahoo and Google. Put together, it still is a little bit of a Wild West out there, and I think it's time that Congress begin to look at that and try to bring some law and order to that particular Wild West area. I see that my time's expired, Mr. Chairman, so I'll submit the rest of the statement for the record. Suffice it to say that I'm glad that you and Congressman Boucher are working with the Republicans and taking a serious look at this. I also want to commend the private sector that's here today. It's my understanding that you're working together to come up with some voluntary rules, and it is always preferable, in my opinion, to do it through a voluntary market-based approach as opposed to a mandatory regulatory approach. So in any event, again, thank you, Mr. Chairman, and once again, congratulations to the Democrats for winning the baseball game last night. I yield back.
The Chair thanks the ranking member. It's now my honor to recognize the gentlelady from California for 2 minutes for the purposes of opening statements. Ms. Matsui.
Thank you, Mr. Chairman. I want to thank you and Chairman Rush for calling today's joint hearing and applaud both your leadership in addressing this important issue. I'd also like to thank our panelists for being here with us this morning. Today we are here to examine the practices and consumer protections from a growing online advertisement practice known as behavioral advertising. As broadband access continues to expand across this country, more and more Americans are relying on the Internet for news information, online videos, and to purchase goods and services. Yet Americans need to have trust and confidence that their personal information will be properly protected. Privacy policies and disclosures should be clear and transparent so consumers can choose what information they want to view and receive on the Internet instead of inappropriate collection and misuse of their information. Consumers should also understand the scope of the information that's being collected, what it's being used for, the length of time it's being retained, and its security. The more information that consumers have, the better. Moving forward, we must ensure that Americans are comfortable with using the Internet and know with confidence that meaningful privacy safeguards are in place while ensuring that we don't stifle innovation. I thank you, both of you, Mr. Chairman, for holding this important hearing today, and I yield back the balance of my time.
The Chair thanks the gentlelady. Now, the Chair recognizes the gentleman from Kentucky, Mr. Whitfield, for 5 minutes for the purposes of... let me correct that. The Chair recognizes the gentleman...
It's okay, I'll not...
No, please, the Chair recognizes the gentleman from Michigan.
I thank my friend, and I'll not take my 2 minutes. That we have great attendance. We'll see what the attendance is after lunch when we return after these votes. I would like to associate myself with Mr. Barton's remarks. The information is yours. When you make a phone call, no matter who it is, you don't expect AT&T or Verizon to share the information with somebody else. You can imagine if you ordered a pizza on the phone and all of a sudden you get different pizza companies then coming in knowing that you're going to be subscribing to that. That information is personal. Shouldn't be shared unless that individual allows and knows that it's going to be shared. It needs to be protected. It's nobody's business. Don't expect to have someone follow you in your car when you go make an errand, whether it be to a dry cleaner or wherever you might go, and expect some competitor then to perhaps get the information to trace you back. So this is a great hearing. I look forward to it, and I yield back the balance of my time.
The chair thanks the gentleman. The chair now recognizes the gentleman from Georgia, Mr. Barrow, for 2 minutes for the purposes of opening statements.
I thank the chairman. I'm going to waive an opening, but I'm going to thank the ranking member for his kind words of congratulations to the Democrats. And in solidarity with Mr. Pitts, I want to remind the ranking member that those of us who sit in the stands and cheer also serve. Thank you very much.
Chair now recognizes the gentleman from Kentucky, Mr. Whitfield, for 5 minutes.
Thank you, Mr. Chairman. We certainly appreciate all these witnesses being here today as we explore this very important subject. As online companies use an array of sophisticated and ever-evolving data collection and profiling applications, it is important that we focus on protecting privacy. Today, I think we'll be hearing about privacy policies of various companies, the data retention that they do. And as we proceed and think about legislation, it's imperative that we use a balanced approach and proceed with caution. And I think if we do have any legislation, it certainly should apply equally to all entities throughout the Internet ecosystem. And I'll yield back the balance of my time.
The chair now recognizes the gentleman from Ohio, Mr. Pitts, from Pennsylvania, Mr. Pitts, recognized for 2 minutes.
Thank you, Mr. Chairman. I worked real hard in the opening statement, but I think I'll submit it for the record. Just let me say, I believe that consumer privacy rights should be carefully guarded. I'm also encouraged by private industry's recent steps to further protect consumers. It's my hope that if legislative action is taken, that we'll do so in a careful manner, striking a delicate balance between the necessary steps we must take to protect consumers and the ability for industry to continue to be successful. So with that, I'll submit the rest for the record and yield back.
The chair thanks the gentleman. The chair now recognizes the gentleman from Georgia, Dr. Gingrey, for 2 minutes for the purposes of opening statement.
Chairman Rush and Chairman Boucher, Ranking Member Radonovich and Stearns, I want to thank you for calling this hearing today on the emerging use of behavioral or interest-based advertising online. While this type of advertising only represents a small portion of all online ads, by 2012, this type of advertising is estimated to reach $4.4 billion in revenue. Therefore, it is important for these subcommittees to take a further look at this industry in order that we ensure the online privacy of consumers. When hearing testimony from this panel today, I believe that it will be important that we focus on 3 components of any potential regulation that these subcommittees propose. First, it's important to distinguish what it is that we are going to be regulating. Currently, most interest-based advertising is conducted through the use of web browser cookies. These encoded text files help indicate a user's online activity, thereby enabling advertisers to customize ads based on a series of preferences. However, as we have seen in the IT industry, particularly over this last decade, technology moves very quickly. And if we are to propose regulations for this industry, then we must make the determination of exactly how and what we are going to regulate. Mr. Chairman, we must also examine which federal agency would be best suited to coordinate any potential regulation. Both the Federal Communications Commission, FCC, and the Federal Trade Commission have jurisdiction over elements of behavioral advertising. Therefore, for the sake of consumers, if regulations are necessary, we must coordinate the efforts and responsibilities of these two governmental entities, thereby allowing for industry growth while at the same time safeguarding an individual's private information. Lastly, Mr. Chairman, we would also have to determine whom we would be regulating. Would it be the Internet service provider, or the advertisers, or the web interfacing companies represented here today? Accordingly, I think it will be important that as we move forward, we diligently take the time to hear from ISP companies and advertisers as a way to give us different perspective on this important issue that will continue to be crucial to the further development of online activity. Mr. Chairman, at the heart of this hearing is the American consumer, so our focus must be their overall protection. I look forward to hearing from the panel, and I yield back the balance of my time.
The chair thanks the gentleman. The chair now recognizes the gentleman from Louisiana, Mr. Scalise, for 2 minutes for the purposes of opening statements.
Thank you, Mr. Chairman. I want to thank you and the ranking members of the subcommittees for having this hearing on behavioral advertising. I'm pleased that both subcommittees are examining this issue as well as the greater issue of data privacy. I know that Congress and this committee have held hearings on data privacy in the past, but as we all know, technology continues to advance and develop in ways that provide tremendous benefits to consumers. But these advancements and benefits can expose consumers to certain risks. Therefore, we must continue to examine ways to ensure consumers don't have their personal information compromised. The technology industry is one of the most advanced and competitive industries in our country. It is also one of the most beneficial, both for consumers and for our economy. We're able to share information, exchange ideas, and conduct commerce in ways that were never imagined just a few decades ago. The industry also provides millions of good, high-paying jobs for people all across this country. One thing that I think that must be pointed out is that the industry has evolved and grown on its own with little regulation from the federal government. Some would say that the government's failure to regulate this industry is one of the reasons it's grown and provided so many good jobs. Yes, there have been bad actors in the industry, and there are issues we must address in protecting consumers' personal information. But I hope that we would proceed with caution when stepping in or when drafting legislation in this area. I hope the focus of today's hearing is how we can protect consumers and their personal information and what steps the industry will take to do that. I hope today's hearing does not focus on how the government can improve the industry. As we continue to delve into this industry and this issue today and future hearings, we should focus on the consumer and what will offer consumers the greatest transparency into the online practices and give them meaningful control over their personal information. For this reason, I believe that self-regulation is sufficient, and if privacy regulatory requirements are needed, they should be consistent across the industry and not be greater for one technology compared to another. Everyone involved in online advertising, ISPs, search engines, advertising networks, website publishers, and others, should all be subject to the same requirements, and Congress should not try to pick winners and losers. After all, consumers are not always aware that their Internet activities are being tracked. They care about what information is collected and what it's used for. They want to know if this is going on, and if so, they should be able to opt out if they so choose, and be assured that a breach of their personal information will not occur. I look forward to the hearing and the comments from our panelists today, particularly on self-regulation and what changes they will make to ensure that protection of personal information and what changes they plan on making moving forward. It is important that these committees and subcommittees understand their positions and activities as well as all the implications of these new advertising practices. Thank you, and I yield back.
The chair thanks the gentleman. As I indicated earlier, there's a vote occurring on the House floor. It's a series of votes, and so we will recess the committee until the completion of those votes, and we will reconvene 15 minutes after the completion of those votes. The committee now stands in recess.